Thanks so much for joining us. I'm Sarah Massler-Donar. There's a new legal battle between Governor Tony Evers and legislative Republicans. The governor is suing them, claiming they're blocking basic government functions. The governor said it's the culmination of a number of actions by GOP lawmakers, including their withholding of pay raises for thousands of people who work for the universities of Wisconsin. He's asked the state Supreme Court to take the case directly.
When the Republicans decided that 35,000 people that work for the UW system shouldn't get a raise without having any legislation that gives them that authority, that's just bullshit.
The governor said Republicans are also blocking some conservation projects and update to the state's commercial building standards. Here now to help us make sense of the law behind the lawsuit is Miriam Seifter, a professor at the University of Wisconsin-Madison Law School, whose research does focus on constitutional and state law. Thanks so much for taking a few minutes to lend some expertise to this issue this morning.
My pleasure. Thanks for having me.
So what does the Wisconsin Constitution say about legislative committee veto powers?
Well, it's interesting. If this were a case about the federal government, the answer would be clear. The U.S. Supreme Court held 40 years ago that legislative vetoes are unconstitutional because they violate the process of constitutional lawmaking. And the vast majority of state courts to consider the question have said the same thing. But Wisconsin is not bound by those rulings, and its case law is a little bit different. In Wisconsin, the separation of powers is understood as a meaningful check, but not a straitjacket. And so the question is always whether the actions of one branch are intruding too far into the work of another branch. When it comes to these legislative vetoes in particular, the Wisconsin Supreme Court has some case law, and it doesn't draw quite as bright of a line as the federal case law. There's a case from the 1990s and another from 2020. And there the court said that legislative vetoes, in that case by the Joint Committee for Review of Administrative Rules, can't be permanent vetoes, but some sort of temporary pause or suspension is acceptable. Now, the current practices of the committees that are at issue are actually not temporary in the way that the court described there. But actually, the lawsuit in this case asks the court to reverse those two cases that I mentioned and hold that even a temporary suspension violates the state constitution's separation of powers.
Now, the governor is saying that actions taken by the committees named in the suit, Joint Committee on Finance, Joint Committee on Employment Relations, and the Joint Committee for Review of Administrative Rules violate the Constitution. So I think you just touched on it there, but can you get into a more specific response of the basis for this argument?
Sure. There's basically two different ways that a legislative veto might violate the Constitution's separation of powers according to the lawsuit. One is that the state constitution sets out a specific way that law is to be made, and that's action by both chambers of the legislature and presentment to the governor who signs it. And the theory of this lawsuit is that what these legislative vetoes are doing is they're actually making law, but they're not using the constitutionally mandated process for doing so. That's one theory. The other theory of the case is that what the legislative veto committees are really doing is executing the law. They're passing the law, but then they're also taking over the executive branch's decision making as to how the law is to be administered. And so in that sense, they're concentrating the power of two branches into one and interfering with the executive function. So those are the two separation of powers arguments that are in play in the case.
So we've talked about the arguments from the governor's side. Republicans have responded to this lawsuit and argued that should the court rule in the governor's favor, actions taken by the committees named in the lawsuit are at risk of being overturned. House Speaker Robin Vos said in a statement that the lawsuit would also eliminate raises given to state employees. So is this a possibility?
It's not clear exactly what the basis for that statement is. It's possible that what they mean is that lawsuits sometimes cause confusion or delays about what the law is while a suit is pending. But here, the people who have already had their raises approved by the legislature and then by the executive branch and then by the Joint Committee would still have those raises approved if the committee is taken out of the equation.
should the governor succeed in this lawsuit, would that make any decisions before the lawsuit by these committees, would that make those decisions retroactively erased?
Typically, no. Of course, whatever court ends up deciding this case will have to craft a remedy, and those remedies typically explain exactly the scope of the ruling. But if they're seeking a declaratory action that the veto power is unconstitutional, then they're probably asking prospectively for future vetoes and continuing vetoes not to be implemented.
The governor has asked the state Supreme Court to take this case directly. Is there an advantage here to bypassing lower courts?
The principal advantage is timing. The lawsuit argues that time is of the essence, and that it would take a long time for this to filter through the lower courts. The lawsuit also argues that this is not a case that requires fact development, which is one of the things that lower courts specialize in, but rather it's a pure question of law that the court can simply decide. And finally, the petition argues that the case is asking for two cases to be overturned and that only the Wisconsin Supreme Court can take that step.
Republicans have also argued that this lawsuit is a way for the governor to limit the power of the legislature and strengthen his own administration. Could this lawsuit set a path to reframing how state government works?
Well, the Constitution's separation of powers contemplates that the legislature does legislation and that the executive branch implements or administers the law. And so at least the argument of the lawsuit is that this would set the government actually back on the path of separated powers, as opposed to allowing the legislature to sort of double down on its power and take additional bites at the lawmaking apple.
Miriam Seifter, UW law professor, thank you so much for taking some time with us this morning.
Thanks for having me.